The email arrived at 4:47 p.m. on a Friday. Subject line, meeting request, Monday 9 a.m. No context. No agenda. Just Jennifer Caldwell from HR and Scott Brennan, the new VP of Product. Dr. Amelia Chen had been with VitaTech Innovations for 9 years. She knew what a Friday afternoon meeting request meant. She spent the weekend reviewing her employment contract. Page by page. Clause by clause. Taking notes. Monday morning, she walked into that conference room with a leather portfolio and the kind of calm that comes from being 3 steps ahead. Scott started with the script. Amelia, we've been evaluating our R and AMP winking and laughing structure, and we've decided to move in a different direction. Your position is being eliminated effective immediately. Jennifer slid the separation agreement across the table. Standard severance. 2 weeks' pay. A non-disparagement clause. Amelia read it slowly. Then looked up. Just to be clear, you're terminating my employment? We're restructuring. Your role no longer fits our roadmap. She nodded. Set down the paper. Okay. Scott blinked. He'd expected pushback. Maybe tears. Okay? Okay. I'll need until end of business today to transfer my files and close out documentation. Security will escort you out by noon. Then I'll work quickly. She signed the agreement. Shook their hands. Walked back to her lab. And spent the next 4 hours filing paperwork that would cost VitaTech $340 million. Hey Tangled Yarns family, it's Brett. And if you're new here, welcome to what might be the most technically brilliant corporate revenge story I've ever covered. Today's story is about Dr. Amelia Chen, a biochemist who spent 9 years developing a revolutionary glucose monitoring technology for a medical device company. A technology that became the foundation of their entire product line. And when that company decided she was too expensive and her role no longer fit their roadmap, she did something perfectly legal, meticulously documented, and absolutely devastating. She transferred the patent to herself before she walked out the door. Let's untangle this. Dr. Amelia Chen joined VitaTech Innovations in 2015 with a PhD in biochemical engineering from Stanford and 8 years of research experience in continuous glucose monitoring systems. VitaTech was a mid-sized medical device startup. About 200 employees. They made traditional glucose monitors, the kind diabetics had been using for decades. Finger pricks. Test strips. Basic technology. But they wanted to break into the continuous monitoring market. The next generation. Sensors that could track glucose levels in real time without constant finger pricks. The problem was that the existing technology was expensive, unreliable, and required frequent calibration. Patients hated it. Doctors didn't trust it. VitaTech hired Amelia to solve that problem. They gave her a lab. A small team. A budget. And one very specific clause in her employment contract that would change everything. Section 7, Paragraph 4, any inventions developed by employee using company resources shall be jointly owned by employee and company, with company retaining exclusive licensing rights during employment. Upon termination, employee retains co-ownership rights and company must negotiate licensing terms for continued use. It was unusual. Most companies demand full ownership of anything you create on their dime. But VitaTech was small in 2015. Desperate for talent. And Amelia's lawyer had negotiated hard. VitaTech's CEO at the time figured it was fine. They'd never fire her. And if she left voluntarily, they'd just negotiate a buyout. Amelia signed. And got to work. For 3 years, she worked 60-hour weeks. Ran thousands of tests. Failed over and over. Refined the technology. By 2018, she'd developed something remarkable. A biocompatible sensor that could remain implanted subcutaneously for up to 90 days. It used a novel polymer coating that prevented protein buildup and maintained accuracy without calibration. The sensor transmitted data wirelessly to a phone app. Real-time glucose readings. Trend predictions. Alerts for dangerous levels. It was everything the market wanted. Accurate. Convenient. Long-lasting. VitaTech filed the patent in 2019. Inventors listed: Dr. Amelia Chen and VitaTech Innovations Incorporated joint ownership, exactly as her contract specified. The product launched in 2020. They called it GlucoSense. Started with a limited release. Rolled out nationally in 2021. By 2023, GlucoSense was generating $180 million in annual revenue. It was 75% of VitaTech's total business. They'd grown to 600 employees. Raised a Series C, were planning an IPO. And Amelia was still in the lab. Still improving the technology. Still developing the next generation sensors. She was making $210,000 a year. Good money. But not remarkable for someone who'd created a product generating $180 million annually. Then in early 2024, VitaTech brought in new executive leadership. Part of the prep for going public. Scott Brennan became VP of Product. He had an MBA from Harvard and 10 years in medical device sales. 0 years in R&amp winking and laughing. His job was to optimize the product development pipeline and reduce overhead. He started reviewing department budgets. Looking for cuts. Amelia's lab budget was $4.2 million annually. Her team was 8 people including herself. Scott saw dollar signs. He didn't see value. He called a product review meeting in March. Asked Amelia to present her current projects. She walked him through the next-gen sensor. Explained the improvements. Smaller form factor. 120-day implant duration. Even better accuracy. Scott interrupted. What's the timeline to market? 18 to 24 months. We're in validation testing now. That's too long. What can we cut to speed it up? We can't cut validation. FDA requires. I'm not asking about FDA requirements. I'm asking how we move faster. Amelia took a breath. We're already moving as fast as safely possible. This is medical device development. Shortcuts lead to failures. Failures lead to recalls. Recalls destroy companies. Scott frowned. I think you're being risk-averse. We need to be more aggressive. I'm being responsible. The meeting ended badly. 2 weeks later, Scott sent an email to the executive team. Amelia wasn't copied, but she heard about it from a colleague. The subject line was R&amp winking and laughing. Optimization proposal. In it, Scott argued that VitaTech should outsource sensor development to a contract research organization. Cheaper. Faster. More scalable. He specifically called out Amelia's lab as high-cost, slow-moving, and resistant to efficiency improvements. The CEO, who'd only been in the role for 6 months, didn't push back. He trusted Scott's expertise. The decision was made. R&amp winking and laughing would be outsourced. Amelia's team would be dissolved. And that's when they called the meeting. When Amelia walked back to her lab after being fired, she had exactly 4 hours before security would escort her out. She spent the first hour backing up her research files to her personal encrypted drive. All her notes. All her data. Everything that wasn't proprietary to VitaTech. She spent the second hour documenting the current status of every project. Where things stood. What needed to happen next. She emailed it to the acting department head. She spent the third hour pulling up the patent records. The GlucoSense patent. Filed in 2019. Granted in 2021. Patent number US 102345667B2. Inventors, Dr. Amelia Chen and VitaTech Innovations Incorporated ownership, joint. She'd always known this. But VitaTech seemed to have forgotten. She opened the USPTO portal. Filed a formal update to the patent assignment records. The update stated that effective immediately, upon termination of her employment with VitaTech Innovations, Dr. Amelia Chen was exercising her co-ownership rights and withdrawing consent for VitaTech's exclusive use of the patent. All future use of the patent would require a formal licensing agreement between the co-owners. She submitted the filing. Paid the fee. Got the confirmation. Then she packed her personal belongings and walked out at 11:47 a.m. Security escorted her to her car. She handed over her badge. Smiled. Said thank you. And went home. VitaTech didn't notice the patent filing for 3 weeks. They were busy. Interviewing contract research organizations. Transitioning projects. Planning the outsourcing. Then the general counsel, a woman named Patricia, got a letter from the USPTO. It was a routine notification. Patent assignment update. Just a formality that goes to all parties on a patent when ownership records change. Patricia opened it. Read it. Read it again. Then she called Scott Brennan. Scott, did you know that Amelia Chen is a co-owner of the GlucoSense patent? What? No. That's a company patent. It's a joint patent. She's listed as co-inventor and co-owner. Okay, so what? So she just filed an assignment update withdrawing her consent for our exclusive use. Silence. What does that mean? It means legally, we can't manufacture, sell, or license GlucoSense without her permission. She's a co-owner. She has equal rights to the patent. That can't be right. We own that technology. We paid for the research. Patricia pulled up Amelia's employment contract. Found Section 7, Paragraph 4. Read it aloud. Oh my God, Scott said. Why would we agree to that? This was negotiated in 2015. Before my time. Before yours. Apparently the CEO at the time wanted her badly enough to accept joint ownership. Can we challenge it? Challenge what? It's in her contract. It's in the patent filing. It's been public record for 5 years. We've been operating under a license we didn't realize we needed. So what do? We call her. And we negotiate. They called Amelia that afternoon. She didn't answer. They sent an email. She responded 2 days later. Dear Patricia, thank you for reaching out. I'm currently reviewing my options regarding the GlucoSense patent. I'll be in touch once I've consulted with my legal and financial advisors. Best, Amelia. Patricia forwarded the email to the executive team. Called an emergency meeting. The CEO, the CFO, Scott, and the head of manufacturing all sat in the conference room looking at each other. How much revenue does GlucoSense generate? The CEO asked. $180 million annually, the CFO said. It's 75% of our total revenue. And we can't sell it without her permission? Not legally, no. What if we just keep selling it? What's she going to do? Patricia, the lawyer, shook her head. She can file for an injunction. Get a court order stopping all sales. She can sue for patent infringement. Seek damages. We'd be in court for years, and we'd probably lose. What if we redesign the sensor? Use different technology? That would take 3 to 5 years. Require new FDA approvals. Cost tens of millions. And in the meantime, we have no product to sell. The CEO rubbed his temples. So we need to negotiate with her. Yes. What do you think she wants? I think she wants to be paid what she's worth. They reached out again. This time through a formal letter from Patricia. Requested a meeting to discuss licensing terms. Amelia agreed. Set the meeting for 3 weeks out. In the meantime, VitaTech's legal team did research. Consulted with IP attorneys. Tried to find a way out. There wasn't one. Amelia owned half the patent. She had every legal right to control its use. And VitaTech had spent 5 years building their entire business on technology they didn't fully own. The meeting happened via Zoom. Amelia on one side. Her attorney on the other. VitaTech's entire executive team on theirs. Amelia let her attorney do most of the talking. Dr. Chen is willing to grant VitaTech a non-exclusive license to the GlucoSense patent for continued manufacturing and sale. The terms are as follows. He shared his screen. Showed a draft licensing agreement. A one-time licensing fee of $15 million for past use of the patent from 2021 to 2024. Plus an ongoing royalty of 8% of gross revenue on all GlucoSense products. License term, 10 years, renewable. The CFO's face went white. 8% of $180 million is over $14 million a year. Correct. That's insane. Amelia spoke for the first time. It's actually quite standard for medical device patents. But if you'd prefer, we can litigate. I can license the technology to your competitors. Or I can simply refuse to license it at all and let your entire product line become illegal to sell. The CEO cut in. Amelia, let's be reasonable here. You developed this technology while you were our employee. Using our resources. Using resources I had contractual rights to. Under an agreement your predecessor signed. An agreement you honored until you decided I was too expensive. We're preparing to go public. These terms would devastate our valuation. Then you should have thought about that before you fired the person who owned half your core technology. The call ended badly. VitaTech tried to negotiate down. Offered $10 million upfront and 5% royalty. Amelia countered. $18 million upfront and 8% royalty. Non-negotiable. VitaTech brought in outside counsel. Explored every option. Tried to find a loophole. There wasn't one. 2 months later, they signed the agreement. $18 million upfront. 8% ongoing royalty. 10-year term. The payment hit Amelia's account in July 2024. VitaTech had to disclose the licensing agreement in their IPO paperwork. It scared off some investors. Reduced their valuation by about 15%. They went public anyway in September 2024. Raised $200 million. But the patent situation was flagged in every analyst report. VitaTech does not own exclusive rights to its core technology. Revenue is subject to ongoing royalty payments to a former employee. It was embarrassing. It was expensive. And it was entirely their own fault. Amelia, meanwhile, took the $18 million and started her own medical device company. She hired 3 of her former team members from VitaTech. The ones who'd been laid off when they outsourced are winking and laughing. She licensed her own patent to herself through her new company. Started developing the next generation of glucose monitoring technology. By early 2025, she'd closed a series of funding round. $40 million. Led by a venture capital firm that loved the fact that she owned her own IP. Her company, Chen Technologies, was valued at $120 million. And every quarter, VitaTech sent her a royalty check for 8% of their GlucoSense revenue. In 2024 alone, that was over $14 million. Scott Brennan, the VP who'd called her too expensive and eliminated her role, quietly left VitaTech 6 months after the IPO. The CEO who'd signed off on firing her stepped down in early 2025. Cited strategic differences with the board. And Amelia kept building. She gave an interview to a medical device industry publication in March 2025. They asked her about the VitaTech situation. She was diplomatic. I'm grateful for my time at VitaTech. I learned a lot. But I'm excited about what we're building at Chen. When you own your own intellectual property, you control your own future. The interviewer asked, do you have any advice for scientists and engineers negotiating employment contracts? Read every word. Understand what you're signing. And if you're creating something valuable, make sure you have a stake in it. Because companies will forget that you built what they're selling. But a patent record doesn't forget. That's permanent. Let's talk about what actually happened here, because this story is about way more than a patent clause. This is about understanding the difference between labor and intellectual property. Amelia didn't just work at VitaTech. She created something. Something novel. Something patentable. Something worth hundreds of millions of dollars. And because she'd negotiated smart in 2015, because her lawyer had insisted on joint ownership, she had rights that most employees don't have. When VitaTech fired her, they thought they were cutting costs. Getting rid of an expensive employee. Streamlining operations. But they weren't firing an employee. They were terminating a business partnership with someone who owned half their core technology. And that mistake cost them $18 million upfront plus $14 million a year in perpetuity. Scott Brennan looked at Amelia and saw a salary. A budget line. An expense. He didn't see the patent. Didn't see the ownership structure. Didn't see that the entire company was built on technology that could walk out the door if they pissed off the wrong person. That's not just bad management. That's catastrophic due diligence failure. And here's the thing, Amelia didn't do anything sneaky. She didn't trick anyone. The joint ownership was in her contract from day one. It was in the patent filing. It was public record. VitaTech just forgot to check. Alright, Tangled Yarns family, I need to hear from you. Have you ever negotiated to keep ownership of something you created at work? IP rights, client relationships, anything? Did it ever save you later? Or have you seen a company fire someone and then realize too late that person owned something critical? Drop your stories below. This is the kind of thing people need to know about. If this story resonated, hit that like button. Subscribe for new stories every single day. And remember, if you create something valuable, make sure you own a piece of it. Because the company might forget you built it. But the patent office won't. I'm Brett. This is Tangled Yarns. And that yarn? Officially untangled. See you tomorrow.